All eyes were on the highest court in the land to give direction on the fulfillment of Article 81B of the Constitution on the 2/3, 1/3 gender principle. Attorney General Professor Githu Muigai had sought the court's advisory opinion on the effective date of the constitutional provision. One school of thought held that the gender principle was effective immediately and that the next National Assembly and the Senate would be unconstitutionally constituted if at least a third of its members were not of either gender. The other held that the provision was to be implemented progressively over a period of time. With a majority decision, the Supreme Court affirmed that there will be no constitutional crisis if Kenyans don't elect a parliament that will have fewer men or women.
That it cannot be enforced immediately. If the measures contemplated to ensure its crystallization into an enforceable right are not taken before the elections of the 4th of March 2013, then it is our opinion Article 81B will not be applicable to the said elections. The
4 judges argued that the provision on gender parity principle had not expressly outlined how it will be achieved, and that the transitional clauses in the Constitution had provided for passage of an enabling law within 5 years to help realize the affirmative action principle as part of addressing years of women marginalization in politics.
We are of the majority opinion that legislative measures for giving effect to the 1/3 to 2/3 gender principle under Article 81B of the Constitution and in relation to the National Assembly and the Senate should be taken by the 27th of August 2015.
However, Chief Justice Dr Willy Mutunga held a different view, arguing that the constitutional provision should be implemented immediately from the March 4, 2013 general election. Dr Mutunga held that Kenyan women had for years been marginalized in the political arena since independence, and that any delay in applying the provision on the composition of the next National Assembly and the Senate would take away the rights that women had been guaranteed by the Constitution.
I believe the immediate implementation of the 2/3 gender principle is also reinforced by the values of patriotism, equity, social justice, human rights, inclusiveness, equality, and the protection of the marginalized.
Dr Mutunga further argued that Article 177(1)B of the Constitution had provided mechanisms on how the 1/3, 2/3 gender ratio would be achieved in the county government, and that the same Constitution cannot deny women their rightful share of the National Assembly and Senate seats.
Arguing that the 2/3 gender rule requires progressive realization flies into the face of this history of struggle by Kenyan women. Katiba Institute is definitely right when it argues that the 1/3 is simply a minimum and that progressive realization must be confined to developments that move the country towards a 50-50 threshold in gender equity and equality.
The Constitutional Amendment Bill 2011, tabled in Parliament by the then Justice Minister Mutula Kilonzo, that sought to clearly outline how the gender principle would be achieved, is still pending in the August House. The advisory opinion rendered by the Supreme Court is binding on all stakeholders in the implementation of the Constitution. However, the Kenyan women can still petition members of the 10th Parliament to immediately amend the Constitution to ensure immediate realization of the 1/3, 2/3 gender principle as outlined in Article 81B of the Constitution. Francis Gashuri, Citizen Live at 9 at the Supreme Court, Nairobi.